Well, that would be intellectually correct. Steyn IP.
Okay, so when David and I went to Cape Town this weekend to go and rescue one of our clients from utter chaos, we realized that there's a lot of misconception about the ownership of intellectual property, how employees work, what the aspects of contractual obligations are, and everything surrounding employment and IP. I think the most important thing we realized is, instead of standing here and giving you guys a presentation of this is IP and this is employment law, explain something that every business should be aware of. And that's how IP functions in employment and how you should structure your contracts, your employment of your IP aspect to ensure that your employees understand what they should do and that you keep your IP safe, even if it's your employees dealing with. So, I mean, the main thing, I think the most important thing to start with is the importance of having employee contracts.
Just to go to that, when you have an employment contract, that employment contract is not just there to protect you while your employee is working for you. When you're dealing with things like your relationship, your product, your data that you have, those have to be protected after your employee leaves as well. And for those, you have two basic protections. One is called the restraint of trade. That's the contractual. And that stops your employee from using the data that they get from working with you to compete with you afterwards. And it's far broader than just, say, the intellectual property portion of it, but it can also be something like your customer lists. And particularly if you're employing salespeople, to go after your customers afterwards and the relationships that they have, if you have a salesman, with those customers and try and steal them from you. But you also have another one, which is called the confidentiality. And that confidentiality is not necessarily to protect competition, but to protect the particular data that you have. So, for instance, if you have a special way of doing business, do not go and implement that at a late stage. And that could include your intellectual property. And then in the situation where you have got the finalization of your contract, you also have your protections while your employee is still an employee of yours.
Yeah.
And the base way of protecting that is by a conflict of interest clause. Now, luckily, our courts have gone and where, you don't actually need a conflict of interest clause. It's automatically read into your employment contract. You have a duty of good faith to your employer. So, Donnie, if your Gendre goes and starts fixing gates behind your back, that's a conflict of interest, and you can fire him for that. The same, Andrew, if somebody likes your Breezebucks idea and goes and calls himself Freezebucks and starts trading in competition with you, you can fire that person. But that also includes elements of intellectual property. So from my perspective, what we would do is use the contract to protect the broad data. The challenge you have with a contract is it can be challenged in court. A restraint of trade can be said, is this restraint of trade fair or not? Confidentiality can say, is it too broad or not? Conflict of interest, is he actually competing with you? There's a constitutional right that says you have a freedom and a right to trade. And that's where people like Christiaan and where Steyn IP does a bit more protection than what we can provide with a contract.
Yeah, so when David deals with the contracts, making sure that employees know where they stand and that your rights beyond IP is protected after the employee leaves. One thing that's important is it needs to be in the contract beforehand, because you can't, when he leaves, say, oh, here's the restraint of trade. He's not going to sign it. You can try it, and you can get David to force him to sign it. He'll likely sign it if you force him to, but there's no obligation on him to sign a document when he already resigned or when you fire. That's where the intellectual property protection comes in. Now, the IP protection, where you challenge a contract, the contractual obligations in court, intellectual property registrations, yes, you also go to court, but it's an absolute right. It's something that's registered, that's defined, and that can be enforced in a multitude of ways. Takedown, for instance. If somebody, we're going to use Don again, if one of your employees decides to open a competing, or ex-employees a competing business with a similar name to yours, you're fine. You've got a trade. You can sue him for trademark infringement. But beyond that, you can just do takedowns of his entire social media and website. We do that in half an hour. No need to go to court. You've got a trademark registration. Thank you, goodbye, take down of his entire online presence. And in today's day and age, try doing business if you don't have an online presence. You can go beyond that and take hold of his domains. If he's got similar domains, again, you need a trademark for that. Patents goes beyond it. Yes, there's a restraint of trade. You've got an employee in the engineering industry. That employee helped you develop a specific product. He then leaves to your competitor and helps develop the competing product. Yeah, good luck enforcing that restraint of trade, because the guy is engineered. He does that. He engineers things. However, if you have a patent or a design registration, you can stop him and the competing company where he now designed a competing product, because it's design or patent infringement. Meaning you don't need to just rely on a contract. You can actually enforce registered intellectual property and prevent competitors that had got hold of your internal data. Yes, employees leave. It is natural. They leave and they will use specific information at their new job. You can't, like David said, a restraint of trade needs to be reasonable. I can't prevent a lawyer from being a lawyer. I can prevent him from using my IP that he used in my office from competing against me. I can't stop him from going to a competitor necessarily. And that's, well, one of the main things that people then also forget is your employment contract or employee. Your employment contract does not need to mention that IP that an employee creates is yours. It will be by default the employer's, unless there's some other form of agreement between you and the employee. If somebody's employed by you, their IP is yours through the course of their employment, meaning it's not just that I appointed Mario to develop an app for me. Mario is appointed to develop an app, but he also made an awesome little logo for me. That logo is also mine. Even if that wasn't his job, he was my employee and he did something through the course of his employment. It's a very broad interpretation. Yes, if he makes music, it's not necessarily mine, but your music sucks, so I don't mind. But that's one of the main things. You have to understand an IP and employment law is actually so closely related to each other when you deal with employees. And whether it's one employee or 50 or 1,000 employees, the principles of employment law and IP is the same. And you have to have it in place, especially if you are a small company. I mean, most of the cases we fight are small companies because, we trust each other. No, but we had an agreement. It was verbal. Now, where's the other law? When last did you enforce a verbal agreement successfully? Yeah.
Precisely. You still wouldn't laugh at
It's something that's notoriously difficult. And most lawyers will be like, no, it's your word against them, good luck. Where you have contracts, where you have IP registrations in place, you are not only protecting your company, but you're protecting the future of your company against employees, because employees leave. There's no loyalty once they left. I promise you that. We've seen it so often. So, I think one of there's a few interesting things that we noticed in this last week where people misjudge their best employees. Yeah, and it's
just like this thing that you and I were talking about yesterday, which I think that touches on employment law as well, where you have to differentiate between independent contractors and employees. And what Christiaan was saying, if you get an independent contractor to build you something, and that IP is actually his because he's building it, he's not an employee of yours. And you last year to check a contract for me where my wife's company employed an independent contractor that developed something very, very special for them, but to protect the IP so that it belonged to the company and not to the independent contractor, and he waived all his rights in developing those independent contractors, those particular intellectual property.
Yeah. We're actually busy with a case like that now. I won't go into the details, but somebody developed an app as an independent contractor. He was paid for it. He developed the app for somebody else. There was no formal assignment. And the person that the app was developed for now says, no, but I made the app. I was the reason the app was developed. I gave you the data, I gave you the resources, things like that. Copyright doesn't care. The app is the owner of the author. The author is the one that created it, unless there's a contract dictating the contrary, or unless he was permanently employed. In this case, he was. So, yes, as easy as IP is to own when it's your employee, if the contract's not right, because that's the other thing we noticed, just because you employed somebody under an employment contract doesn't mean he's necessarily an employee. If your contract is not right, there's a loophole. And lawyers are good at finding loopholes.
Definitely.
We are.
I know particularly in construction industry, electrical industry, etc., where you use people, it's oftentimes you don't want the schlep of having an employee working for you because there's lots of requirements and payments, and so it's easy then to go, well, why did we make him an independent contractor? And that works. There's ways and means to do it. But if that independent contractor then learns about your business through being an independent contractor, there is no restraint of trade. He's not an employee of yours. There's nothing, if he himself develops some inventive way of doing the business that you do, it's his. You can't take it away. So you need to have those protections for independent contractors in place as well. And there's a pathetically easy way of getting out of those restraints of trade as well, is if you go to court and you have to prove that it's reasonable and fair. The courts don't like restraints of trade. If I then prove or go along with the dismissal, I prove the dismissal was unfair, there's a read-in clause in every single employment contract that says you're entitled to be treated fairly. If the CCMA says you were treated unfairly, the employer has breached the contract. Guess what happens to your restraint of trade and your confidentiality? It's gone because you breached the contract. That's why having the additional protection of going, okay, but there's IP and there's other laws and other ways of interpreting the protections that go into IP.
Yeah, so I think the main thing you guys need to remember, and also when you see other people and advise what we can help for, is to ensure that they understand they likely don't know everything, and they need to make sure that people like David and myself and other, this is just two of the facets of it. If you're in a company, your contracts and your compliance are essential. That's where some of our other colleagues come in. You need specialists, and specialists work together to ensure every single point works. So, I think on that, just how do you get clients for us? Most people would need us. It's essential. Even though people don't like lawyers, we are essential. We do fulfill a function that people need before they realize they need it. And like insurance, it's better to have it beforehand than when you need it. Okay.
Thank you very much. Thanks for your time.
Thank you very much.